Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. So I am back here again with the landmark judgments for the 15 days. This is a very interesting series that has been started at LegalBee. So don't forget to subscribe to LegalBee for that purpose. आपको सारे landmark judgments के updates इस एक single compilation video में मिल जाते हैं every 15 days. If you have not checked out the previous videos, do check it out. This has been started from the month of January. Every 15 days, I try to bring to you all the landmark and the judgments not only of Supreme Court but also of some high courts that have been delivered within those 15 days time span, which have really discussed some important aspects of law and which every law student should know, every lawyer should know, those who are preparing for competitive exams where you have legal GK as a very important part, or if you are preparing of course for judiciary examinations, आपके लिए ये वीडियो बहुत ही ज़्यादा beneficial होने वाला है. It is a very crisp content that has been given to you. Also, you can do one thing, you can download the PPTs of all these videos and keep it as a record with yourself of all the judgments. It is like a judgment compilation for you. So take benefit of all these things, download the PDFs also and PPT as well. Don't forget to subscribe to the YouTube channel and अगर आपके कोई queries हैं आप हमें इस नंबर पे कॉल कर सकते हैं या फिर आप इस वीडियो के कमेंट सेक्शन में भी लिख सकते हैं. If you have any doubts and genuine queries, you can also write to us at hello@iexambee.com. The landmark judgments I will be dealing with March 1st to March 15th, 2023. इस दौरान जो भी लैंडमार्क जजमेंट्स पास किए गए हैं बाय द ऑनरेबल सुप्रीम कोर्ट एंड ऑल्सो ऑफ सम हाई कोर्ट्स वी विल बी डिस्कसिंग इन दिस वन वीडियो इन अ वेरी crisp manner. First one, Rajendra Kumar Srivas versus State of Madhya Pradesh and others. This is a judgment delivered by the Honorable Supreme Court of India. इस केस में को वारंटो की रिट सीक की गई थी by the appellant. He had prayed for the writ of quo warranto to be issued against the High Court of Madhya Pradesh at Jabalpur. It is relating to appointments and appointments that are being made by way of limited competitive examinations in judiciary itself. And the appellant said that it exceeded the quota of 10%. 10% से ज़्यादा exceed हुआ था जो appointments हुआ था in the higher judiciary, and that limit of 10% has been set by the Honorable Supreme Court only in the case of All India Judges Association and others versus Union of India and others 2010. So this was not followed and the High Court has actually High Court has actually rejected the plea that was filed by the appellants before High Court as well against the same thing. And Supreme Court has ruled in favor of the appellants and has asked the High Court to check what has been done actually, and limited departmental competitive examination से जो appointments हुए थे क्या वो really excess में थे, and if it is in excess then the further excess posts should be adjusted in the future recruitments. This should be done by the High Court. ऐसा डायरेक्शन सुप्रीम कोर्ट ने दिया है. Second, Nandlal and others versus State of Chhattisgarh. This is a judgment important in the criminal law section. Why it is so important? Because in this again the Supreme Court has acquitted the accused on the benefit of doubt. All such kind of judgments are very important, especially judiciary examinations के लिए ये काफ़ी important है. And जो लोग practice कर रहे हैं उन्होंने भी updated होना चाहिए ऐसे सारे recent judgments से, and they can use these as precedents in their cases. It will definitely help them a lot. The reasoning that Supreme Court had given was that taking into consideration the delay in lodging the FIR with the circumstances of their names not being mentioned in the documents, at least the contemporaneous ones, the possibility of said accused being falsely implicated cannot be ruled out. So in our view, the conviction of the accused is purely on the basis of oral testimony, and that too of an interested witnesses. If the oral testimony is of interested witnesses, automatically the value will be lowered. The value of evidence will be lowered. So there is no sufficient corroboration also to accompany it. So this kind of conviction is not sustainable. This was held by the Supreme Court in this particular judgment, and the accused was convicted was acquitted for the benefit of doubt. Mohinder Singh through LRs and others versus Narayan Singh and others. This is another judgment given by the Honorable Supreme Court. In this case, appellants have challenged the judgment and order passed by the Honorable High Court of Delhi, holding that once there was a rural area which was urbanized by issuance of a notification under Section 507A of the Delhi Municipal Corporation Act 1957. So it was requested that it ceased to be governed by the provisions of the Delhi Land Reforms Act 1954, because the new notification had come under the Municipal Corporation 1957 Act. So now that area has come under Urban Municipal Corporation area and is no longer a rural area. So the proceedings under the 1954 Act were non-est. These are leaving the parties to agitate their claims or disputes before appropriate forum, clarifying whatever pleas they are having in law. So in this case, why this case is important and I have taken up for discussion basically is that the apex court has ruled in favor of the respondents and has tried to do complete justice as per Article 142 of the Constitution. There are certain cases where Supreme Court is having powers to do complete justice and do something which is not specifically asked for in the petition. Court is having a vast discretion that has been given to it by Article 142 of the Constitution. This was the reason that I wanted to discuss the judgment with you. You can go through the details of the judgment for your understanding, especially about the facts of the case. And the apex court has directed the appellants to hand over the physical possession of the land that was subjected, and it should be free from all the encumbrances, and it should be handed over to the respondents within period of 2 months from the date of passing of this order. This was held by the Supreme Court. Basically, the land was sold to the respondents, but yet they did not get the possession. So Supreme Court has tried to do complete justice and has asked the appellants to hand it over to the respondents within 2 months from the date of this order, and that is what the Supreme Court has done for doing complete justice in this particular case, because the sale deed was actually executed in favor of the respondents duly from 1989, but still they have not got the possession. Pawan Kumar Chaurasia versus State of Bihar. In this case, the accused had filed an appeal against the judgment and order of conviction. Remaining 4 accused, who were the co-accused along with him, were actually acquitted. Only he was convicted. So his conviction was based on extrajudicial confession, and that's why he approached the High Court. High Court rejected his appeal. Others were acquitted by the High Court, the 4 co-accused. So he approached the Supreme Court, and when he approached the Supreme Court has actually considered his plea that the extrajudicial confession was actually discarded. Extrajudicial confession was discarded as already it is a weak piece of evidence. Court has held that, observed that it is a weak piece of evidence generally, and a conviction cannot be sustained on the basis of extrajudicial confession provided the confession is proved to be voluntary and truthful. It should not be with any kind of inducement, and it should not be made to somebody who is a complete stranger. It should be made to somebody who is a person who is related to that person, or that person is having implicit faith in that person to whom the confession is being made. So all these considerations were made by the Honorable Court, and the court has observed that in this particular case, benefit of doubt has to be given, and the conviction cannot be solely relied on the basis of the weak evidence of extrajudicial confession in this case specifically, as per the facts and circumstances of this case, and there is no such kind of corroboration as well. So there is no credibility that can be attributed, and the accused was actually acquitted in this case. Ashutosh Samanta through legal heirs and others versus SM Ranjan Bala Dasi and others. In this case, the Honorable Supreme Court has talked about the validity of order of trial court, which was actually upheld by the High Court of Calcutta as well, relating to grant of letters of administration. So the apex court has again upheld the judgment. The court has said that the grant of letters of administration was correct. It was, though the witnesses who have signed the document are not alive, but applying section 69 of the Indian Evidence Act, both the attesting witnesses have died, but the two sons of the testator, they have made a deposition that when the will was being signed by him, they were present and they have given statement for that purpose. Their statement has been subjected to cross examination as well, and after that will deed, actually the document was actually, after that partition deed was also executed, and it was not contested by other parties. So automatically the reliability of that particular document cannot be challenged, and it was upheld. And Supreme Court also has upheld the decision of High Court of Calcutta as well as the trial court. Ganesh Prasad versus Rajeshwar Prasad and others. In this case, the plaintiff has filed a suit for redemption in mortgage, and in this, an application for amendment was also filed. But that amendment application was rejected by the trial court and also by the High Court when he went in revision against that amendment order. So the matter has reached Supreme Court. Apex Court also dismissed the appeal. And what was the point of discussion over here was relating to redemption, which is actually a part of substantial law. The point of law that was being discussed in this particular judgment, that is important, that if right of redemption is existing, then the provisions like the provisions of CPC basically, which is a procedural law, it can never bar the mortgager from filing a second suit, because the cause of action in that redemption suit is going to be recurring one, which is actually arising out of a partition suit. So the cause of action is successive in nature, and right of redemption is extinguished, or a suit for redemption is time barred. That is a different thing, and this is a different thing. This has been clearly differentiated in this particular judgment. This judgment actually you will not be able to understand in very short. Actually, it is having various areas, and I have taken a very short instance over here. Maybe it can get confusing for you because the judgment is very diverse. It is having various things, and इस judgment को short करना इतना आसान नहीं है. I would suggest that you people go and check this particular judgment in detail. Try to go through in detail that what was the actual scenario and how this point of law that was decided came into picture. I have not taken up the exact facts of the case in this particular video due to time constraints, but I would suggest that you do refer this particular judgment. It covers the aspects of redemption as well as amendment as well as CPC provisions. So this is very important for civil law. Union of India and others versus Union Carbide Corporation and others. Another very important order that was passed recently, Bhopal gas tragedy related. Bhopal gas tragedy victims have got compensation by the Union Carbide Corporation. Everybody knows the facts of Bhopal gas leak case. So there was a petition that was filed, a curative petition that was filed by the Union of India before Supreme Court for enhancement of compensation to all the beneficiaries. But the court has rejected this. Court has said that the concern would be further amplified in respect to that tort claim of absolute liability that was passed. And if evidence was to be led for each claimant in this case, then it would not be feasible to do that. Rather, it will cause detriment to the beneficiaries only. So the court has rejected it and has also added that the money was needed in the immediate aftermath of the tragedy and not after 3 decades. Thus, finally, finality was already reached when the decision was made at that time, and there is no need of any enhancement in compensation. This was the decision that was given by the Honorable Supreme Court, and the plea was rejected. S. Athilakshmi versus the state represented by drugs inspector. This is also a unique case. Actually, the petitioner, she has filed this particular particular case before the Honorable Supreme Court for quashing of FIR that was filed against her. She has come in special leave petition. It is an interesting case. Actually, why she has come before the Honorable Supreme Court? Because criminal proceedings were initiated against her under the Drugs and Cosmetics Act. You can check out the provisions in detail. So these sale of drugs and cosmetics that was punishable under Drugs and Cosmetics Act 1940, those sections were applied against her just for keeping some small amounts of lotions, creams, and such kind of materials, and all the details you can check out in the judgment that she was having with her. She is a registered medical practitioner. She was actually teaching also as an associate professor in a college for some time. So the court has considered that the small quantities of medicines cannot amount to sale of those medicines or stocking for the sale, basically keeping a stock for sale. What the drug inspector has come to a conclusion to is not by any stretch of imagination, that is not a valid conclusion, and that's why the court has quashed the criminal proceedings against her under Drugs and Cosmetics Act. S. Nithya versus District Collector and others. This is a judgment by the Honorable Madras High Court against Revenue Divisional Officer. Revenue Divisional Officer, he has actually neglected his duty of issuing a caste certificate to a child. The child the child is having parents from different castes, so he had approached for caste certificate, and when there is a settled position of law that when the child is having parents from different castes, there can be any caste certificate granted to him, either his father's caste certificate or his mother's community. It depends upon their how they have decided, and in this case his mother had already given an undertaking for the same, that his father's caste certificate shall be granted, that their father's community they are belonging to. That kind of undertaking was also available, but still the revenue divisional officer did not apply his mind, and he did not consider this particular case and refused that particular duty. He refused his duty, he neglected his duty, and that's why the court has actually imposed a fine of 50,000 rupees on him, which was later reduced to 10,000 by the additional government pleader. Mr. Sankar Viswanath versus State of Karnataka. Karnataka High Court has given another interesting judgment relating to custody of a child. The husband was living in Germany and he sought the custody of his child, who is staying in Bangalore with his grandfather, with his mother. So the court has rejected his plea and has given judgment in favor of custody of the child with his mother. The court has said that at present it is in the best interest of the child that the child should live in Bangalore. It is a conducive atmosphere for him to live with his mother and the grandparents. He's living there for the last 5 years, so that minor child was not given in custody to his father in Germany, in the best interests of that particular child. This was held by the Karnataka High Court. Mahavir Senior Model School and another versus Directorate of Education. This is another interesting judgment that has been given on 15 March by the Delhi High Court. The High Court of Delhi has dismissed the petition. That petition was challenging a maintenance of surplus amount by the private educational institutions that is being collected. It is not necessary that if the private educational institutions are collecting some surplus amount, it is going to be collected as for commercialization of education purposes. The Department of Education is very wrong in holding such kind of things. Accumulation of surplus funds by the private institutions is not necessary, that is, it is for commercialization purposes. And the court has held that these surplus they actually require in development and for growth, because private unaided institutions require a lot of funds. So the accumulation of surplus funds is essential for their long-term sustainability as well. So that's why the court has ruled in the favor of institutions, private unaided institutions, that it is incorrect and impermissible for the Department of Education to make such kind of statements that this is commercialization of education. So this was all that was there from the landmark judgments that I had to give you all within these 15 days. I hope this video has been very beneficial for you and very concise for you. Do check it out. If you want any details, you can write to us at iExamBee. Don't forget to subscribe and prepare 50% faster for your exams with iExamBee. Thank you.